let me now invite to deliver concluding remarks José Manuel Gutiérrez Delgado, who is head of the International Arbitration Department of the General Attorney's Office of Spain. And as all of us know, Spain has been quite busy recently in the area of investor-state dispute settlement. So José Manuel has a wealth of experience dealing with international investment law, and he spent over 30 years working in various senior positions in many different fields at the Ministry of Justice, Ministry of Economy and Taxes. He also has served as a director of 5 state-owned companies, and he also used to live in the UK, working as financial counselor of the Spanish embassy to the United Kingdom. So José Manuel kindly agreed to deliver closing remarks, which were partly prepared in advance and partly reflect what we have already discussed. José Manuel, the floor is yours. Please unmute yourself.
Yes. Okay. Thank you very much, Jarek, and thank you to the Investment Treaty Forum and the British Institute for this invitation to be here and to make these closing remarks for this quite interesting conference yesterday and today. Thank you to all the people who attend this event, who is the most important people in the event, because without them we are not going to be, this would not have any interest. And I would like to I'm going to show you, share my screen with all of you, because as Jarek said, I prepare some remarks, some final remarks, but I want to make some additional comments with the very interesting things we have been able to hear in this conference yesterday and today. So let me share my screen with you. And I'm going to talk to you, I will not be more than 10 minutes, because it's, I don't want to take more time, because you probably will be tired after these 2 days, and it's Friday evening, and you can enjoy you will be willing now to enjoy your weekend. We have a very sunny afternoon in Madrid and Spain, and I hope you have the same in London or in any part of the world where you be. The right to regulate, which is one of the most important concepts that we have heard in this conference, we can say that it has been a strong, probably, obviously recognized, but as well even a strength in the last awards that we have received in the last months. Awards so important as Saluca or Total or Mikula have definitely recognized the right to regulate of sovereign states, and so we have heard today, this afternoon, this right to regulate is even strength in the last years. The FET standard is not properly an stability clause. It respects the right to regulate of the sovereign state and the necessary to adapt to changing circumstances, including fiscal, environmental, or whatever other circumstances that can change and make necessary to change the regulation in any way. This right to regulate have to be considered in the necessary changes that sometimes happens. For example, COVID and the pandemic crisis that we have this year is something that obviously could not be expected in any way, And it's obvious that the states have to make some measures, have to take some measures, and have to modify the law and modify the regulations in order to adapt to these circumstances that never could be prevented, and have the right to do this. Not only the right, but probably the obligation to do this and to preserve many other public interests. What are the investors' base concept is the legitimate expectation. The legitimate expectation have to be balanced with this right to regulate of the host state. And we have to consider two special points to make this balance. The reasonable, if the legitimate expectation are reasonable, or they are over any reasonable point of view, and if there is any specific commitment made by the host state in the situation. Investors have the right to, as well, to stable conditions, but the stable conditions does not prevent from regulatory flexibility. Stable conditions refer to the framework and not to any specific measure or any specific regulation. It refers to have a framework and a stable and a business and economic framework, but not necessarily refer to any specific situation and any specific measure that can be adopted. It's not an stability clause, it's the right to a stable condition, but it's not exactly an stability clause, and it has to consider new circumstances. And when we evaluate if we are preserving and we are inside the stable conditions that must be guaranteed to the investors, we must evaluate how the investor decision was taken and why the investor's decision was taken. And in this point, it's very important to consider the due diligence, as we heard in the roundtable of yesterday afternoon. Due diligence is something that is getting more and more important in the international arbitrations, and is the way to prove and the way to show how the investor took the decision and why took the decision, and if these have been really affected by the measures adopted by the host state. At the end of the day, we have to make a balance. We have to make a balance between the effects of the measures and the affected rights. But we have to make a balance, according to awards like Saluca, Arif, or PV investors, we have to make a balance as well between the measure, the policy of the state, and what is the state looking for. If this measure is aimed, if this measure is reasonable and balanced for getting this target of the state. Otherwise, it will not be acceptable. If you have a right target and you are looking for something that is right for the host state, your measures have to be adapted, have to be followed, have to be according to this target and what you are looking for. Otherwise, it will not be an appropriate measure. And but that doesn't mean that the state always be right. The state can be wrong and can take a measure that is not, it not works at the end of the day. But in any case, it can be in the same direction that what you are looking for and the objective of the host state with the measure. The state have a margin of appreciation, have the right to regulate, and have the a margin to appreciate how this regulation made. If the regulation is reasonable, if this regulation is in the line of the objective that the state want to get, and if this regulation respect the previous specific and particular commitments, the state will be inside the margin of appreciation, will be inside the margin given by the investment treaties and given by the customary international law. Otherwise, it will be out or over this margin of appreciation. But investors also have a right to freezing of regulation. The stability of FET implies the stability of the legal and business general framework, but doesn't mean the virtual freezing of the regulation. in the absence of specific promises, the investors cannot rely on an insurance policy for legislation completely free. The changing of the regulation is part of the regulation and is part of the way in the regulation and the laws develop in any country, adapting to several circumstances and several changes. And this is a part of the environment in which the investment should develop. So no investors can rely on freezing of the regulation. Moreover, if the state or if the investors are trying to understand and the state is making a commitment to never change its regulation, this will not be conceivable. In my opinion, it's not conceivable that a state make a commitment not to change the regulation forever, because sooner or later, the new necessities, new circumstances, the evolution, the changes in public services, in infrastructures, in whatever will make necessary to change the regulation. That's not the point. The point is not to freeze the regulation. The point is that the changes of the regulation be inside the stable framework, be reasonable, be according to the state targets, and be without breaching the previous commitments. But never any state can reasonably accept that they are going to freeze the regulation. And once again, think about the COVID pandemic this year. What would happen if any state would have made the commitment to freeze the regulation in any of the aspects that it has been necessarily modified with the crisis derived from the pandemic. And investors cannot be protected unconditionally. I mean that investors can be, not only can, should be protected, of course, but they don't, they are not entitled to ask for protection over macroeconomic, consumers, market, or even sometimes the eventual bankruptcy of any economic system of the state. They cannot ask for levels of yields over what is reasonable or what is the rest of the interest in any other investment in this country or any other investment in the world. The protection is a protection balanced, reasonable, but never unlimited and out of not considering any other circumstances of the macroeconomic situation or the situation of the economic of the country, of the system in which the investor is developed. Let me make a quick reference to the Energy Charter Treaty, because as Jarek said in my presentation, in the Kingdom of Spain, we have a lot of cases in connection with the Energy Charter Treaty. And I would like to make some very quick remarks about this treaty. The Energy Charter Treaty is a good example of this balance between the right to regulate and the investors' interest that should be protected. They try to balance, the treaty tried to balance the sovereign right of the state to energy resources. Look, that this is a question in which sovereignty is especially present, and the necessary flow of investments to the energy system. They have to they are trying to promote long-term cooperation in the energy field when it is particularly necessary, a long-term protection and a long-term cooperation because of the huge investments that must be done to create the infrastructures and the energy infrastructures. But this does not mean that the state does not have the right to regulate. Article 10 of the ECT demands stable conditions, not a frozen regulatory, once again, as we have explained in general before. It's not an insurance policy about keeping the regulation absolutely freeze, and accept a reasonable evolution of the host state law and consider that this must be part of the environment within which investor must develop his investment. As I said before, I don't want to be over my 10 minutes. And once again, thank you very much for your invitation to this keynote at the end of the conference. And thank you very much for your attendance. Thank you.
Thank you very much, José Manuel, for this excellent summary of many of the issues which we discussed today. And on this note, I would like to conclude this conference. I hope that you found this conference useful and interesting. I found it a bit difficult to sit in my chair for 2.5 days. So when you have a normal offline conference, it's a bit more fun. So hopefully the next big event will be an offline conference in spring in London. But we hope to have a few smaller online events before the end of the year. And we're always interested in hearing your thoughts about the format of events, your ideas about new events. If you are a government which hasn't joined ITF yet, please think about it because it's free. If you're a law firm or a practitioner, you also approach me and I'll explain more if you need more information. So follow BICL on social networks, and I wish you well and have a nice weekend. Thank you very much, everybody.
Thank you very much. Have a nice weekend.
Bye-bye.
Thank you. Have a nice weekend too.
Thank you. Have a nice weekend. Thank you very much. Nice to meet you.
Thank you very much. Same here.
Okay.
All the best.
All the best.